So you're like, good.
We are meeting after a gap. Good evening to all of you. We are meeting after a gap of 2 days because we had some practical problems. The last we had our YouTube connection only till 15th, so there was this time lag as far as the taking a new idea and all. That's the reason why we are start today. Welcome to the lecture after 2 days. Today the topic for today is Limitation Act, or in Telugu it's called Parimitalu Chattam, or in Urdu it is called Muddat Ke Kanun. Here, everything should have a particular time. Everything should have a particular period. Every claim has to be brought within a particular period, and every claim should be brought within a particular period so that the other side is not taken by surprise. Here, before we go into the Limitation Act, Limitation Act is of 1963, where it says there are certain periods mentioned for bringing an action before a court. And this is based on the maxim. That is one. There is a maxim called "Ubi jus, ibi remedium." That is, wherever there is a right, there is a remedy. But as far as Limitation Act is concerned, it operates as a limitation to say that all actions will have to be brought within a particular duration of time. And if it is not brought within that time, you may have the right, but you don't have the remedy to approach the civil court. That is the reason why stale claims should not be brought before the court, and that is the reason for which the Limitation Act is enacted. Here, you may have the right, but if you don't come within the particular time as stipulated in the Limitation Act, your remedy is barred. You cannot knock at the doors of justice to get your grievances redressed. That's the reason why the Limitation Act is based on the maxim vigilantibus, non dormantibus, jura subvenient. Vigilantibus, vigilantibus, vigilantibus. Right. Vigilantibus, non-dormantibus, NON space, dormantibus, 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 jura, JURA space, subvenient, SUBVENIENT. That means law comes to the rescue of a person who is vigilant about his rights, who is conscious about his rights, who takes the earliest available action to bring a suit or bring a claim before a civil court and does not dilly-dally the matter and does not wake up like a Ripvan Winkle after 24 or 20 years and then bring an action. Please remember, though you may have a right, but you cannot knock at the doors of a civil court. That is the reason all state claims cannot be brought before the court, and that is the reason why Limitation Act is enacted. That is the introduction as far as the Limitation Act is concerned. Limitation Act consists of two parts. One is called the sections, and another is called the articles. But as far as the sections are concerned, as far as the law schools are concerned, the syllabus that is prescribed in the law schools is articles are not referred, only the sections are referred. Articles only when you come to practice, they are referred in our day-to-day practice. Today, our ambit is very, very small because we are going into only the introduction of the Limitation Act. I will deal with the sections first. The sections are concisely called the substantive law, and the articles are called the procedural law. Sections are called the substantive law, and articles are called the procedural law. Here, limitation. The aim and object of limitation is to prevent stale claims being brought before the court. A person who slept over his rights for a long duration of time should not be given a redress as far as a civil court is concerned, and that is the reason the law of limitation operates as a bar to bring stale claims before the court. That is, in other words, law of limitation says all actions which you have to bring before a civil court should be brought within a time frame. Here, the first and foremost section, which I'll deal only with in a concise form because substantive law hardly consists about 14 to 15 sections, and each section is a topic by itself. First and foremost is, I think most of you know that we come up Article 1, 2, Section 1, 2, 3, 4 are not very important. Section 5 of the Limitation Act plays a very important part. For example, when I've discussed civil procedure code, I told you just an example I'm giving you. When I was discussing the civil procedure code, when you file an application, let us say, to bring the LRs on record or the legal representatives on record, either under Order 22 Rule 3, Order 22 Rule 4, or Order 22 Rule 9, the period of limitation is fixed. That is, as far as the LRs are concerned, Order 22 Rule 3, when the LRs of the plaintiffs are to be brought on record, a period of 90 days is given to you from the date of death of the deceased, within which you must file a petition. 90 days period is to bring the LRs on record. And then if you don't bring the LRs on record within 90 days, then a 60 days further period is given to you, whereby you can file an application under Order 22 Rule 9 to set aside the abatement. Order 22 Rule 9 to set aside the abatement, because if you don't bring the LRs on record, what would happen is it is as good as the suit is dead as far as that person who has expired. So that is the reason Order 22 Rule 3 says whenever the plaintiff dies, the action does not die with the plaintiff. His LRs can maintain the action, but you must file an application under Order 22 Rule 3 CPC within 90 days to bring the LRs of the plaintiff on record. And when you file such an application under Order 22 Rule 3, you are supposed to mention also the consequential amendments which you have to make in the plaint. Please remember, consequential amendments is contained in Rule 28 Civil Rules of Practice. By adding the new LRs on record, what are the remedies which are open to them, and whether they stand taken by the plaintiff. Naturally, they stand by that, and whatever extra grounds are there, they can mention it in the consequential amendments. And for example, the prayer clause also, you must be very careful to say wherever the word plaintiff is mentioned, it should read as plaintiffs. Why? Because the LRs of the plaintiff are trying to come on record. And the period, and Order 22 Rule 4 deals with a situation where one of the defendant dies. It is your duty as a plaintiff to bring the LRs of the defendant on record, and by filing an application under Order 22 Rule 4 CPC. And within what time you must bring that application, sir? You must bring that application within a period of 90 days from the date of death. And suppose, let us say, one of the defendant dies, you do not know his LRs, and then you want to know the LRs and their addresses. Then you can file an application under Order 22, Rule 4A, asking the court to direct the defendant to furnish the names of the LRs of the deceased and also their respective addresses. Then, suppose, let us say, you don't bring the LRs on record within 90 days. Normally speaking, the suit also dies or suit abates because you have not brought the LRs on record. But there is an enabling provision called Order 22 Rule 9, that is to set aside the abatement where you are not able to bring the LRs on record within 90 days period. A further period of 60 days is given to you under Order 22 Rule 9, where you can file an application to set aside the abatement. Let us say even after 60 days you are not able to bring the LRs on record. 90 plus 60 is 150. Then you come to the Zinda Tilisman as far as Limitation Act is concerned, that is Section 5. That is condonation of delay in filing the applications within time. Then every days of delay you will have to mention, and also say that the delay in filing the application for setting aside the abatement or bringing the LRs on record be condoned. And then what the court does is it issues notice to the opposite side, and the opposite side is given an opportunity to file the counter, and the application is heard, and then it is disposed of. First, the delay petition is disposed of, and normally in the delay petition, what happens is the court awards cost to the opposite side to be paid by you in case of any delay. 30 days delay means 1 rupee per day. That is 30. That is normally 100 rupees, 200 rupees, 300 rupees, or whatever it is. Then once the delay is ordered, next comes the next step. The next step is the abatement, setting aside abatement petition will be heard, will be argued, and the abatement petition will be allowed. Then comes the last one, is bringing the LRs on record. Then bringing the LRs on record, then you argue the matter, automatically it will be ordered. There's no problem for that. But once your LR application is ordered, you are supposed to amend the plaint and also incorporate amended and added as per, that is, whoever is the deceased plaintiff will say, died per LRs, amended and added as per orders in IA number so and so, dated so and so, and put a bracket in, and then what whomsoever you are adding, you need incorporate their names in the plaint, and then also whatever consequential amendments which you have sought in your application, you carry out those amendments also, but be careful in mentioning that amended and added as per orders in IA number so and so, dated so and so. Then the next step is you are supposed to file a fair amended plaint into the court, fair, neatly typed, and whatever amendments you have carried out, you will have to incorporate them and file a fair copy. This is how the steps are taken as far as LR application is concerned. And Section 5 deals with a scenario where you do not file the LR application on time, that is within 90 days. The setting aside abatement within time, that is 60 days, 90 plus 60, 150 days. After the expiry of 150 days, you file an application to condone the delay in filing both the petitions. So the steps that are taken by the court is your delay petition will be numbered as IA, but your other IAs which are there, setting aside abatement, bringing LRs on record, they will be in the SR stage, that is in the suit register stage. It will not be numbered as interlocutory application till such time your delay petition is disposed of. Then, as far as Section 5 is concerned, normally the courts are very, very liberal as far as condoning the delay is concerned. Even the government sometimes what happens is they file an application for under Section 5 to condone the delay of 1,000 days or 1,500 days or 2,000 days. Courts are not harsh enough to dismiss applications filed under Section 5. But one important thing is you must mention the cause. Sufficient cause has to be shown why the applications were not filed within time. Are you able to understand, please? Then we go to Section 9 or Section 10, which says that as far as what is called when time begins to run, it does not stop. When time begins to run, it does not stop. What do you mean by that? Suppose, let us say, a judgment is passed on 10 6 2024. The time for filing an appeal is what you call is 1 month in case of the district court and 3 months in case of high court. And let us say you file a copy application. Then let us say you do not watch the copy application. Your copy application is stuck off because you don't pay the copying charges. Then you file a restoration petition, and your restoration petition is ordered, and then you deposit the charges, and then your copy is ready. Then here, let us say, when the time has, suppose, let us say you are supposed to file a suit, or suppose you are supposed to file an appeal before, during the vacation time. Then the question is, the period of limitation starts running from the day, suppose, or your application is returned, let us say. Your application is returned on the last working day. You do not take subsequently you take the return of the papers, and you are supposed to represent within 7 days. And during vacations, normally the SR register is closed. SR register will the papers will not be entertained during the vacations, any vacation, Dasara vacation or summer vacation, it will not be received. You are supposed to represent or resubmit the papers on the reopening day. Please remember the word reopening day has got significance. Suppose the courts are opening on 10th of June, then let us say the court says for the purpose of filing, 8th will be the period of limitation. On 8th, you take the bundle, resubmit the bundle, and file it in the court which has returned it. Then you save the limitation. But you allow time to lapse, and let us say you wait till July or August and you don't resubmit the papers, then time has already begun to run. Then in that case, what happens is you will have to file it with a delay petition under Section 5. And because the time has already started running, it does not stop. Time and tide wait for no man. That is a normal proverb in English. In the same way, as far as Limitation Act is concerned, any papers returned during the vacation period has to be resubmitted on the reopening day, which is fixed for filing or resubmitting the papers within time. Then, in case there is a delay, then you will have to come under section 5, show sufficient cause why you could not resubmit the papers within time. And that's why it is said when time begins to run, it does not stop. Are you able to understand, please? Then the next topic here is um, filing the copy applications. Suppose a judgment and decree is passed. If you are a successful party, you don't bother about it. But if you are the unsuccessful party, you don't file it within time, and let us say, or you don't pay the copying charges, then you will have to get the CA restored. File it under Rule 201 of the Civil Rules of Practice to restore your CA before the district court, and the district court approves the application and permits you to deposit the copying charges, so you get the benefit of limitation. It will be taken as if you have deposited the stamps within time, and your suit will be within time. So here, when calculating especially the number of days to prefer an appeal, the time taken for copies, obtaining copies, the judgment may be passed on 10th of June, but the copies are made available to you only on 30th of June. How much time has expired, sir? 20 days it has been spent for taking copies. The period of limitation starts from 30th of June and not from 10th of June. Why? Because the day when you obtain the copies, the period which is spent for taking copies is excluded for the purpose of limitation. Is it clear to you, please? Then we go to what is called uh, section 17 and 18 of the Limitation Act. This is very, very important, sir. Why? Because normally, whenever money suits are filed, they are filed by your clients only on the last date of limitation. How to come within the period of limitation? 17 and 18 says, suppose there is an acknowledgement in writing, suppose there is an admission of liability in writing, suppose there is correspondence between the parties extending the time, or suppose there is an endorsement on the reverse of the negotiable instrument, let us say promissory note or whatever it is, that some amount has been paid, then the period of limitation gets extended, and that writing which is there, that endorsement which is there on the reverse, extends the period for a further period of 3 years, and this is called acknowledgement. But that acknowledgement which has to be taken within the period of 3 years, not beyond that. And what the bankers normally do is, the bankers, in order to keep the matters alive, suppose a promissory note is about to expire on a particular day, and before that they call the customer and ask him to pay 1,000 rupees or 2,000 rupees into the account. And once he deposits that 1,000 and 2,000, they also take what is called AOD, acknowledgement of debt. Then they take COB. AOD means acknowledgement of debt. COB means confirmation of balances. And third one is they take revival letters also. All these three documents under section 17 or 18 of the Limitation Act extends the period of limitation for a further period of 3 years. And this in law is called acknowledgement. But that acknowledgement has to be taken within the before the expiry of the 3 years period. That is what section 17 and 18 says. And normally, the literacy in the villages is not that much as we have in cities. So, in villages, what they do is, on the reverse of the promissory note itself, ఈ రోజు నాకు 500 రూపాయల రొక్కము నగదు ముట్టినది అని that fellow will sign and put the date. And every payment made endorsed on the reverse of the promissory note or a negotiable instrument extends the period of limitation for a further period. And sometimes what happens, novation also takes place under section 61 and 62 of the Limitation Act, where the old contract is substituted by a novatio contract or a new contract or a supplemental agreement is made by and between the parties. The supplemental agreement, which is executed by and between the parties, extends the period of limitation as far as performance of the respective obligations between the parties are concerned. So, as far as acknowledgement is concerned, it plays a very important part, vital part, as far as extending the period of limitation, provided, again I'm saying, provided it is taken within a period of 3 years before the claim becomes time barred, and it's an unequivocal assertion or unequivocal admission made by the party or undertaking made by the party that he is due and payable or is indebted to you, and he pays a particular sum towards the installment, and that particular sum extends the period of limitation, and it amounts to admission and acknowledgement of the liability as far as the debtor is concerned. Then, sir, we pass on to the last topic as far as the substantive law is concerned, that is to say, persons suffering from legal disability. Who are the persons who suffer from legal disability, sir? You have to again refer to Section 11 of the Contracts Act, which says a person of but that is a person who is a minor, a person of unsound mind, a person who is an idiot, or person who is otherwise disqualified by any law for the time being enforced. All these people are supposed to suffer from legal disability. Again, in this case, I will give you an example, sir. Here, as far as a minor is concerned, any contract entered into when the person was a minor is not enforceable either by himself or against him. And as far as a minor is concerned, no doubt a minor cannot be a partner in a partnership firm, but he can definitely be admitted into the firm to share the profits of the business. As far as assets and liabilities are concerned, he is no way responsible. But once he attains the age of majority, he has got the option of electing whether to abide by the contracts which have been entered during his minority or not. And once he elects that he doesn't want to be bound by the original contracts, then automatically it goes. So that is the reason a person suffering from legal disability is first is a minor. Second one is a person of unsound mind. A person of unsound mind, I think, he is a lunatic. He is not able to discriminate between good and bad, and he does not know the consequences of what he is doing. Then, whatever contracts or whatever acts are had and received by the minor or, I'm sorry, by the unsound person or against the unsound person, they cannot be enforced till the cessation of his disability. The period gets extended. Then the third one is an idiot. Idiot in Telugu they call it as idod, and in Hindi they call it as Aula Pasha. That means he does not know what is good, what is bad. He is not able to discriminate between good and bad, and is not able to have a rational judgment of what he is doing. Then these people, idiots, are supposed to be incompetent to enter into a contract, and they are people suffering from legal disability. And in that case, the period of limitation gets extended till such time till the cessation of his idiocy. Then persons disqualified from entering into a contract. Who are those persons, sir? A person who has been declared as an insolvent by an insolvency court, a person who has been disqualified for moral turpitude, a person who has been who has been disqualified for under any law for the time being enforced. And as far as those people are concerned, the period of limitation gets extended till such time that disqualification goes. So these are all the 4 or 5 topics which are there in the substantive law, that is in the form of sections. Then we come to the procedural law. I will only give you an introduction to procedural law because I want to go as slow as possible, because this is one of the most important enactments which has a day-to-day application in our profession. Here, there is first article is Article 1, and to put it in straight, articles are from Article 1 to Article 137. Article 1 speaks about current, open, and mutual account. Current, open, and mutual account. What do you mean by current, open, and mutual account? Here, all loans, all credit facilities given by the banker, or let us say all loan transactions between a creditor and a debtor is a current account. And as far as a Marwadi is concerned, the account is entered in a book called the Khata, or what is called the account book, or what is called the big book, where it is mentioned. And as far as the banker is concerned, the banker gets so many documents executed, but You cannot get a loan unless you open a current account. So current account is a must or is a sine qua non for grant of a loan or a grant of loan facilities by the bank. And that is the reason you open a current account with the bank and also give an undertaking that all your transactions you will route it to the bank and you will not route it independently. And once a current account is open, please remember current account does not carry any interest. And as far as a current account is concerned, it's a day to day transaction intercede the banker and the customer. And why is it called current account? Is current account means everyday transactions are there. Usually mutual credits are there, mutual debits are there, mutual disbursal of loans are there, and mutual what you call when the customer receives the sale proceeds, he deposits it in the account, then takes it from the account, and it's kept open. Open means it is not closed. Then mutual. Mutual means there are current, open, and mutual. Mutual means there are mutual credits and mutual debits on either side, and it is called a mutual account. And that is the reason under Article 1 of the Limitation Act, it says as far as current, open, and mutual account is concerned, the limitation starts running from the last date of credit or last date of debit, and not from the day when the loan is disbursed. So that is the reason, sir, why the bankers, whenever they draft a plan, in the limitation paragraph, they say the suit is within time and within the period of limitation, as a suit account is in the nature of a current, open, and mutual account, and the last credit into the account was on so and so date, and it is within the period of 3 years as stipulated under the law. So this is what Article 1 states. Then I'm only giving an introduction, please. I'm going to discuss it in detail when we start the articles in the right earnest. The second one is the period of limitation for filing a suit for declaration or cancellation. This is dealt with by Article 58 and Article 59 of the Limitation Act. It says that a suit for declaration or a suit for cancellation has to be brought within 3 years from the date of accrual of cause of action. Article 58 and 59 says a suit for declaration or for a cancellation has to be brought within a period of 3 years, 3 years from the date of accrual of cause of action, and that is and if you file it beyond 3 years, it is time barred. So that is Article 58 and 59 of the Limitation Act. I'm only giving an introduction, please. We'll discuss it in detail when I come to it in the subsequent class. Then Article 54 is a very, please note down, please. Article 54 is a very important article as far as we are concerned because it deals with limitation of suits for limitation for filing a suit for specific performance. Limitation for filing a suit for specific performance. As far as Article 54 is concerned, it says whenever there's a time fixed under the agreement, the limitation period is 3 years from the date mentioned in the document for performance of the obligation. The first limb of Article 54 says, as far as limitation is concerned, filing a suit for specific performance, the limitation period is 3 years from the date if the date is fixed. 3 years if the date is fixed for performance of the respective obligations on either side. Then 54 proviso is there where it says if no time is fixed for performance of the obligations, if no time is fixed for performance of the respective obligation, the period of limitation is 3 years from the date when the refusal or inability of the opposite side to perform his obligations. It is called the proviso, where it says the period of limitation starts running when the opposite side refuses to perform his obligations under the contract. Here, why I'm trying to tell you this is this here, sir. Here, suppose let us say I just take a hypothetical case. Suppose an agreement of sale is made, sale is made. It's a written document. Suppose let us say normally, sir, every contract has to be supported by consideration. Suppose, let us say, I agree to purchase the property for 1 crore. Out of 1 crore, I pay in advance and earnest money of 20 lakhs, and the remaining 80 lakhs has to be paid within 6 months from the date of agreement, or it has to be paid in a phased manner. And let us say the last date of payment for final consideration is, full consideration is, let us say the agreement is made on 1/1/2024. Suppose the last date for payment is 1/7/2024. 6 months period is given. Then subsequently, what happens is the vendor, even after the time of 1/7/2024 expires, he receives the balance of the sale consideration in installments till 1/12/2024. Are you able to understand, please? You have to make the payment within what date? By 1/7. The entire full payment has to be made by 1/7. But the vendor receives the money even after 1/7 and receives it in installments and receives it till 1/12/2024. Then when does the period start, sir? The period starts from the date of the supplemental agreement, the date, the conduct of the party vendor receiving the money even after the expiry of the period mentioned for payment amounts to what is called a novation. Novation means the original contract gets substituted by a novatio contract, and the obligations and the new contract alone has to be performed, and the old contract gets extinguished. Are you able to understand, please? So, to be on the safe side, what we do is we give a notice calling upon the vendor, sir, I've already paid the entire amount. Please come and execute and register the sale deed. The vendor cannot take a ground saying that the time for payment has expired and so you are not entitled for specific performance. Here, whereby, or the vendor keeps quiet, he does not give a reply. That conduct itself shows that the vendor has dissociated himself from performing his obligation, and it amounts to refusal to perform the obligations, and that is the reason you get a fresh period as far as the limitation is concerned. Are you able to understand, please? So, ఇంత గిట్టుకుంటుంది అనమాట. So, specific performance, don't take it easy. It's as simple and as complicated as possible. Why? Because the other side will come out. Please don't expect the other side to sit like a dummy. He will contest your suit. He will take all defenses possible. He will take all grounds of attack possible. But you must have the wherewithal how to counter it. That is the reason, sir. Whenever a novatio contract takes place, you try to give a notice to the opposite side, take his reply, and then file a suit. Then let us say the original contract is modified.
Is he audible? Is he audible? Yes. Okay. అడిగే కొంచెం రీసౌండ్ వస్తుంది.
The original contract is substituted. The original contract is substituted by a novatio contract. So, in the complaint, you have to carefully mention these allegations to sustain the suit for specific performance. Because why I'm telling you all these things is, I faced a similar scenario in a particular case. What happened was the agreement of sale was executed by the vendor in the month of March of a particular year. Then the payment was not payable immediately, but it was payable in a phased manner. By May, a particular amount has to be paid. By July, a particular amount has to be paid. By September, a particular amount has to be paid, and the rest of the money has to be paid in October of that year. But what the vendor did was he received the money even after October of that particular year. It means it's a condonation of the lapse committed by the purchaser and the vendor having received the amount even after the stipulated date. It amounts to novation. It amounts to substitution of the old contract by a new contract. In that case, you give a notice to the opposite side. I am ready and willing to perform my obligations. Please come and execute and register the document. And on the failure to do so, you initiate an action under the Specific Relief Act under Section 10 and file a suit for specific performance and take the defense of Article 61. Take the defense of novation under section 61 and 61 of the Contracts Act to say novation has taken place and the new contract alone has to be performed. A period of limitation start from the day of the supplemental agreement, not from the original. So these pleadings have to be clearly mentioned. Then, sir, I'm only giving an introduction, please. Then we go to Article 61 and 62 of the Limitation Act. It says, within what time the mortgagor has to file a suit for exercising his right of redemption. Within what time a mortgagor has to file a suit for exercising his right of redemption. Previously, the period of limitation was 60 years from the date of executing the mortgage. But after that, it was reduced to 30 years. Within 30 years, the mortgagor can always bring a suit for redemption, that is, to take back the property, getting the mortgage cancelled, and getting back all his securities, provided the right of redemption has not been extinguished by a decree passed by a court in a suit brought by the mortgagee. In those circumstances, the mortgagor can exercise the right within a period of 30 years. Then what about the mortgagor, sir? Mortgagee, I'm sorry. Mortgagee is concerned. Mortgagee to enforce a contract and enforce his right to impose a charge on the property which he has taken. He has to bring the suit within 12 years from the date when the mortgage money is due. So, as far as the mortgagor is concerned, it is 30 years. But as far as the mortgage is concerned, to bring a suit for foreclosure or sale of the property, it is 12 years. Then, to claim an easement, what is the period, sir? To claim an easement or a right over a neighbor's property, how much of possession is required? It says 20 years uninterrupted possession is required to claim a right of easement. What an easement is? A right which you enjoy over your neighbor's property, like light, air, sanitation, ventilation, right of ingress and egress, right of worship, right of passage, right of irrigation water, which you have been enjoying for a period of 20 years uninterruptedly, that cannot be disrupted. And for that, the limitation period is 3 years. Then, sir, then as far as when no, as far as mortgage is concerned, for suit for redemption is 30 years under Article 61 by the mortgagor, and suit for foreclosure or sale is 12 years from the date when the mortgage money becomes due. As far as promissory note is concerned, it is 3 years, not more than that. I think this is the introduction part of it as far as the Limitation Act is concerned. And I will deal with it in detail because I don't want to hurry up. We will deal with it in detail because we have started a new topic. That's the reason why I gave you the introduction of the Limitation Act. And Limitation Act is it's called Gadula Chattam, or it's called the Parimita Chattam. That is, within what time a suit has to be brought, or within what time a suit has to be brought before a civil court. All these things are laid down in the Limitation Act. So this is as far as the introductory part of Limitation Act is concerned. Though it's not exhaustive, it is only in brief. Then continuing with the revision which we were doing for the benefit of people who have joined late. Here I think we were dealing with the Civil Procedure Code, if I'm correct. There we were dealing with the stages of a suit. Here the first stage is filing a document into the court called a plaint. Then after that, the next then the plaint is presented before the proper court, and then it is checked by the section, and then it is entered in a register called the suit register, and then it is sent to the court for the purpose of verification. అదే ఇది ఇంట్రడక్షన్ అయిపోయింది లిమిటేషన్ యాక్ట్ ఐఎమ్ డూయింగ్ దట్ సిపిసి 8:15 దాకా పెట్టింది అవునప్పా సిపిసి రివిజన్ కొంచెం మిగిలిపోయింది అది చేసేస్తాను సో యాజ్ ఫార్ as So the stages of the suit you have to remember. But before going to that, in brief, I will deal with the amendments, new amendments which have taken place as far as the Civil Procedure Code is concerned. Here in 1970, the original Civil Procedure Code is of 1908. It underwent an amendment in 1976. It was called the Act 46 of 1976, whereby new provisions were added. The important provisions which were amended was the provision relating to what is called attachment and arrest before judgment, that is order 38. There they say an attachment cannot be ordered straight away without hearing the opposite side, and then in that case what the courts used to do is the court used to issue conditional attachment. That means if other party is asked to furnish security for the suit amount with the cost, and then notice is issued to the opposite side to appear and show cause why the attachment should not be made. Then the opposite side files a counter and files the documents, and the matter is heard threadbare and appropriate orders are passed. So the 1976 amendment straightaway bars the court from passing what is called an ex parte attachment orders. But earlier in 1908 code, straightaway when you ask for attachment, it used to be ordered, but sometimes it used to lead to misuse also. Why? Because a property worth about for 4 lakhs or 5 lakhs is attached for a debt of 400 rupees. So to prevent that, the amendment was brought in 1976. The other amendment that was brought in 1976 code was, as far as law of injunction is concerned, that is order 39. There they say that the court cannot straightaway order an injunction. Court, what it has to do is it has to issue notice to the opposite side, hear the opposite side before passing an injunction order. And that is the reason they issue other notice. But sometimes when the party insists on appropriate orders being passed, the court issues what is called status quo orders, that things stand where they are, and you are supposed to send the copies of the documents, copies of the plane, copies of the petitions to the opposite side by registered post, and in case an injunction is granted, and then file an affidavit under Order 39, Rule 3 of affidavit of compliance, and then file the postal receipt also along with that, so that the injunction will be communicated to the other side. So by the amendment of 1976, ex parte injunction orders cannot be granted, but in case the ex parte injunction orders has to be granted, the court has to record reasons and state why issuance of notice to the opposite side will frustrate the very purpose of the suit, and it should be a speaking order, then alone injunction can be granted. Then we go to the next amendment that was brought in 1999. Various amendments were brought, sir, in 1999, but 1999 amendment was a stillborn child because it gave rise to nationwide protests because it was against advocates, where they say, suppose you file a suit for injunction or for attachment, and suppose your allegations are found untrue, you must furnish security for the cost of the defendant before you file the suit. This was really unjust, sir. Why? Because we advocates draft a suit as per the instructions given by the party. We are not concerned with the facts of the case. We are only agents of the party. We try to put it in writing what the client has instructed us to write, and then to ask us to furnish security in case your allegations are found untrue. You must compensate the other side by cost. Is it not unjust, sir? That is the reason why it was opposed, and it was a stillborn child. And 1999 Act was not implemented. Amendment was not applied at all or not implemented. Then we have the present amendment of 2002, Act 22 of 2002, which came into effect on 1/7/2002. Nearly 24 or 26 amendments were brought by this particular amendment. The first amendment that was brought was that Order 5. Most of the delays which occur in court, most of the delay which occurs in the court is because of non-service of summons. Because summons take a very long time to get served on the defendant. Because the defendant manipulates with the process server or the postman and gets the summons returned. And for that reason, they have introduced the amendment by saying you can send the summons either by court, registered post, courier, speed post, electronic mail service, WhatsApp, or by email. You can send it by speedier mode of service, but provided you file the tracking record also to show that it has been sent to the other side. Then the next amendment, second amendment, which was brought, was the amendment to Order 6, Rule 1, where they say all prints will have to be filed in duplicate, duly signed by the party, and one extra copy for the computer or one extra copy for the scanning purposes. It is absolutely mandatory that Order 6, Rule 1 has to be complied. Then the next amendment that was brought was Order 6, third amendment was Order 6, Rule 15, bracket 4. What does it say? Verification affidavit. Please remember, verification affidavit means where verification affidavit means here it saves the advocate, sir. So in the verification affidavit, you say that the averments that are made in the plea are drafted as per the instructions given by the party, and they are mentioned with full restraint and responsibility, and they are true and correct. The party signs and verifies it. So, what is the advantage an advocate gets, sir? An advocate gets an advantage of saying that the averments made in the plea are drafted as per the instructions given by the party, and the party himself has stated so, and therefore he has verified it. But one more provision is there in Andhra area, where under section 26 bracket 2, they file a further affidavit by saying that the averments made in the plane are true and correct. It's only multiplication of what. Then next amendment that was brought, the fourth amendment is Order 6, Rule 17, bracket 2. That's the fourth amendment. Here, Order 6, Rule 17, bracket 2 says, I think what is Order 6, Rule 17, sir? Order 6, Rule 17 is amendment of pleadings. Here, previously, we advocates on the civil side, we used to have a gate time as far as this Order 6, Rule 17 is concerned. We can delay the matter as far as possible by filing amendment petition after amendment petition, then get it dismissed, go to the High Court, get it allowed or get it dismissed, go to the Supreme Court, and then come back. Then take some other ground and you want to amend it. Like that, you are going on only with the amendment petitions. But what used to happen is a lot of time used to be consumed. So they introduced a restrictive clause, that is Order 6, Rule 17, bracket 2. Amendments cannot be allowed as a matter of course. Amendments cannot be allowed as a matter of course unless and until certain special circumstances exist, and amendments cannot be allowed once issues are framed and the parties file their respective evidence affidavits before the court. Are you able to understand, please? When you can't file amendments, sir, when the issues are already settled, when the parties have already filed their evidence affidavit, their matter is ripe for trial. At that stage, you cannot file an amendment petition except in exceptional circumstances. It is not available to you as a matter of right. Everywhere, our hands of our advocates are tied. So you cannot have a gate time as far as amendment application is concerned. Please note the amendment provisions are Order 6, Rule 17, bracket 2, CPC. That's the fourth amendment. The fifth amendment that was brought is Order 7. In Order 7, they introduced a new clause, Order 7, Rule 14, bracket 2. That is, whenever documents are filed by the plaintiff, after the plaintiff is filed into the court, any additional documents that are filed can be filed under the provisions of Order 7, Rule 14, bracket 2. Earlier provision was we were filing the applications under Order 13, Rule 2. Order 13, Rule 2 no longer applies as far as documents filed by the plaintiff subsequent to the filing of the suit. That is the fourth or fifth amendment. The sixth amendment that was brought about is Order 8. Order 8, Rule 1 speaks about filing of written statements. I still remember, sir, in the olden days, people used to take 2 years, 3 years to file a written statement. But now your wings are clicked. Here you have to file the written statement within a period of 30 days from the date of service of summons on you, and that is the rule, Order 8, Rule 1. Then the court can extend time from time to time, not beyond 90 days. First one is Order 8, Rule 1, which has been amended 30 days from the date of service of summons. But Order 8, Rule 2 says the court can extend time for a period not exceeding 90 days. Then The next provision which was amended was Order 14. Order 14, please tell me, sir, what does it deal with? It deals with issues. Order 14, Rule 5 was introduced, whereby they say all scandalous, vexatious, or insulting allegations which are made in the pleadings, the court can order them to be struck off and removed from the pleadings and a fair copy being filed. That is the Sixth Amendment. The Seventh Amendment, which was brought about, is Order 18, Rule 2, bracket 3. Order 18, Rule 2, bracket 3. That is, written arguments can be filed by the parties. Much of the time of the court is taken for arguing a matter for days and days and days together. To prevent such things happening, the Order 18, Rule 2.3 has been introduced, whereby you have to submit arguments in brief within the time allotted by the court, and within 7 days from the termination of the trial, you are supposed to file written arguments before the court after serving a copy on the other side, and the other side has also got a time of 7 days for filing its written arguments. I tell you the reason why written arguments has been introduced, sir. The written arguments has been introduced because some of us are good in oratory. We go on talking blah blah blah. Some of us are good as far as writing is concerned. A good writer need not be a good speaker. So, and sometimes most of us come from the vernaculars also. Our English is not that strong as we expect. In that case, written arguments come in handy for you so that the judge also cannot close his eyes in deciding a particular matter. You can raise all points in the written arguments. But a corresponding provision is there in your CRPC also. Of course, the old CRPC, I'm talking about section 314, which says written arguments can be filed by the parties in support of their case. So it minimizes the time of the court in hearing arguments. Then the next amendment that was brought was Order 18, Rule 4 and 5. That is, all evidences in chief shall, not may, shall be filed by an affidavit. And the cross-examination can either be recorded by the court by itself or delegated to an advocate commissioner to record the cross-examination and file a report into the court. Order 18, Rule 4 and 5 says that all evidences in chief shall, not may, shall be filed by an affidavit. And then the documents which you are relying upon will be marked by the court. And the cross-examination will either be recorded by the court itself or delegated to an advocate commissioner to record the cross-examination and file the report. This is 7th or 8th amendment as far as CPC is concerned. The next amendment that was brought about was Order 20. Order 20 previously, whenever arguments are heard and whenever written arguments are also filed, the court can reserves the case for passing judgment. What is the period within which it has to pass the judgment, sir? Earlier it was 14 days. Then it was extended to 30 days. Because of pressure of work before the courts, now it has been extended up to 60 days. Within 60 days, a judgment can be passed, provided notice is given to both the sides and the judgment is passed in the open court. Then the next amendment that was brought about was the here what is called Order 41. Order 41 deals with filing of first appeals. Whenever an appeal is, whenever 3 or 4 suits are clubbed together and a common judgment is passed, then in that case, you need not file the decree in every appeal. You can file the decree in one appeal, and the other appeal you can say you have filed it in the common judgment appeal. The first appeal itself you have filed, and it can be treated as. And please remember, now earlier an appeal can be filed only with a copy of the decree. But if the copy of the decree is not ready, not made ready by the court, you can file an application to the court. Sir, dispense with filing of the decree copy. As and when the decree copy is obtained by me, I'll file it in the court. Then you can file the appeal even without a copy of the decree. Then, sir, these are the amendments as far as the substantive provision, the procedural aspect is concerned. And here, one more thing you must remember is 148 in the 1976 code, Before 1976 code, we did not have the caveats. Now, the caveats have been introduced by 148A by the Amending Act of 1976, whereby you can say that no order, ex parte order should be passed without notice to you, to your advocate, and then only after notice is given, the caveat is numbered, and then the matter is heard. Without notice to the caveator, the suit cannot be heard. Then 148 also is introduced, whereby they say that any application that is returned, the period of resubmission is within 30 days. It has to be resubmitted. And here, one more amendment which has come is Order 21, Rule 97 CPC. That is when the auction, when you are questioning the auction by filing an EA, it has previously you have to file it within 30 days. Now within 60 days, you can always file a claim petition before the court. So these are the various amendments that were brought about by the various amendments of the Civil Procedure Code right from 1976 up to 2002. Then, when we were dealing with the stages of the suit, the first stage is filing a document into the court called a plaint, and plaint is normally filed under the provisions of Section 26, read with Order 7, Rule 1 and 2 CPC. I have also gave you the ingredients of the contents of a plaint, how it has to be drafted. Then the next one is the name of the court, then so and so, number of this OS number of whichever year, and between so and so plaintiff, between so and so defendant, and then address for service, and then your address, who is appearing for the party, then the address on the defendant, and then brief facts of the case. And what is more important in a plaint is cause of action. In most of the interviews and most of the JCJ examination, the question of cause of action is asked. What do you mean by cause of action? A bundle of facts and bundle of documents put together, clubbed together, which constitutes the causes for an action in a civil court. The bundle of facts and documents in the form of causes, which gives rise to an action in a court of law, is called cause of action. Then jurisdiction. Jurisdiction is, I told you also, it is three types: pecuniary jurisdiction, territorial jurisdiction, and subject matter jurisdiction. Pecuniary jurisdiction means every court has got a right of hearing matters up to a particular limit. As far as now the subordinate judiciary is renamed as district judiciary. It's not subordinate judiciary anymore. It is called district judiciary. It's a three-tier compartment. It comprises of the principal district judge at the fulcrum, assisted by additional district judges. Then below him, you've got the principal senior civil judge, assisted by additional senior civil judges. And last is the principal junior civil judge, assisted by the additional junior civil judges. It's a three-tier compartment. Pecuniary jurisdiction is, it doesn't remain static always. It moves from time to time. Here in 1972, when the City Civil Courts Act was passed, which was applicable to the Twin Cities or the metros, it was said that till 5,000, you can file a suit before the municipal court. Those days, they were called municipal courts. And above 5,001 to 20,000, you can file a suit before the sub-court or the sub-court. Then above 20,000, 20,001 to 50,000, you can file it before the district court. And above 50,000 also, unlimited district courts used to have power. Then slowly it went on being increased. And today the value has been fixed previously. I think if I'm correct, it's 2020 or 21 or 22. The jurisdiction of a junior court was enhanced to 20 lakhs. And above 20 lakhs till 50 lakhs, it was the senior court. And above 50 lakhs, unlimited, it was the district court. But now I was told, of course, subject to confirmation, that the jurisdiction of the principal junior civil judge has been reduced from 20 lakhs to 10 lakhs. That is still 10 lakhs, it is the junior court, and above 10 lakhs, 1 to 20 lakhs, it is a sub court, and from 20 lakhs 1 to 50 20 lakhs 1 to 50 lakhs, it is a senior court, and from above 50 lakhs, district court has got unlimited jurisdiction. I tell you why these amendments have been brought about. These amendments have been brought about because the High Court does not want to hear any matter, and they want any matters in appeal, and they want the matters to be thrashed out at the grassroots level itself. That's the reason why the district judges have been given enormous powers to hear appeals. Then, sir, territorial jurisdiction. Territorial jurisdiction means, in Telugu there is a word called Sthanabalam. That is, wherever the document is executed, and you are strong at your place, and you may not be that strong when you go to another place. So that is the reason. Suppose a document is executed at Nalgonda, then Nalgonda court alone has got jurisdiction. You cannot file a suit in Hyderabad. Then you got what is called subject matter jurisdiction. Now we are in an era of specialization where tribunals are being constituted to hear specialized matters like cooperative societies, housing societies, trade union matters, labor matters, family court matters, then chit fund matters, then customs matters, excise matters, then rent control matters, and so on and so forth. Where tribunals are constituted, you have to go only to the tribunal, you cannot come to a civil court. And Section 9 of the Civil Procedural Code says all matters of civil nature can be filed in a civil court except those expressly barred. That is, when the special courts are constituted, you have to go to those special courts alone. You cannot go to a civil court. Then you must mention the jurisdiction part of it very carefully. Here I'll give you one hint, a practical hint, sir. Suppose there are got four or five properties. One property is at Nalgonda, one property is at Khammam, one property is at, let us say, in Sangareddy, so on and so. But one property is at Hyderabad. How do you retain your client with you? You can say part of the property mentioned in the schedule is at Hyderabad. Therefore, the court at Hyderabad has got jurisdiction to try the matter. Then the court fee you vary according to the relevant paragraph, relevant section of the Court Fees Act. Then after that, you say no suit has been filed, and then you say how the suit is within time. Last one is a prayer clause. And prayer clause, when you write, please be very careful, make it as small bits A, B, C, and D, so that it gives more clarity. And then the party signs and the party verifies, you also sign, and the list of documents the party also signs. And then if it's regarding immovable property, you mention the schedule of property, give its boundaries, and the schedule also is verified, and the party signs, and you file it. And all prints have to be filed in duplicate, and along with that, you have to file the evidence verification affidavit under Order 6, Rule 15.4, and along with that, you must also file an affidavit under Order 6, Rule 14, giving the addresses of the plaintiff, giving the addresses of the defendant, and also saying that the addresses mentioned above are true and correct, and the party sign. And then then you have to pay then you have to file the wakalat nama, that is signed by the advocate, signed by the party, and then which gives you the power to represent the party. Then you also file the bata, or what is called process, under Form 61, and also file the settlement of issues form if it's the original suit. Three forms for each party, and then the process. If you ask for any interim orders, also you pay the process, and also includes duplicate in the form of show cause general, and you also enclose the copies of the papers which you are relying upon. And then after that, the list of documents also you have to file, that is filed under Form 51, and then supply as many copies as there are defendants and file the same into the court. And once the plaint is ready in all respects, you go to the court and file it before the allotment judge. And when you want urgent orders, you file it in the form of an out of order petition, and then state the reasons why the matter is urgent, and then you want urgent orders. Then it goes to the section. It is entered in a register called the SR register, and then placed before the CMO, who scrutinizes the plaint, and then presents it before the allotting judge. And the allotting judge, if he finds that all the formalities have been complied with, then orders for registration of the suit, and the matter is heard in the afternoon, and the orders are passed accordingly. This is how the civil suit is run, sir. With this, we shall stop, and we go to the interaction period, if any, today.
Madam, unmute everybody. Madam, unmute everyone. Done? Good evening, everyone. Sir.
Good evening, sir.
Good evening.
Please raise your hand before you ask a question. May I know who is this? May I know who is this?
Please go ahead, sir.
Please go ahead. Please go ahead. don't know who is that. Please mention your name in bar association before you ask a question. Vasandra Guru.
Good evening, sir.
Good evening. Again, sir.
Sir, I am from Khammam, sir.
Yes, sir.
I have one question, sir.
Please go ahead.
My client purchased a property, sir.
Right.
And he paid the full consideration.
Right.
Since the defendant is not coming forward to register the CLVD, he filed a suit for specific performance.
Right.
In the meanwhile, my client came to know that was mortgage required of title to the one bank.
Mortgage.
So what is the
you have
mortgage?
the mortgagee to whom it has been mortgaged. You must. The documents must be with the mortgagee.
Mortgage, yeah.
So
that was not reflected.
See,
That is simple one.
it's a simple mortgage, is it?
Yeah.
So if it's a simple mortgage, you deposit whatever is the mortgage money into the court. And then, or you make the mortgagee a party to the suit and ask for redemption also against that mortgagee, saying that you're prepared to pay the mortgage money.
Then what is the problem is that the property worth of 30 lakhs, whereas the mortgage amount is 18 lakhs. And my client has paid total consideration 30 lakhs.
Right. The other liability remains, isn't it, sir? The mortgagee's liability of the excess of 50 lakhs, isn't it, sir?
Excess of 30, but what the problem is, she has no other problems.
Then the question is, he has purchased it subject to the mortgage. The mortgagee will have a provincial right. Whether you like it or not, you have to discharge the debt.
Of course, sir, it is correct, but it was not before purchasing the property, after the EC from the register office. But it was not reflecting.
Sir, it will not reflect because bankers take only equitable mortgage. They usually take only documents. They don't take a registered document. It will not be shown in the encumbrance certificate unless it is registered.
Then my client has to put for the remaining 80 lakhs.
Yeah, he has to pay that whether he likes it or not to the mortgage.
Then he has to make a part to the bank and he is ready to pay the...
Exactly. And also make a mention, because we also face a similar situation. You also say that you went there to the bank to redeem the documents. Banker said, unless the entire amount is paid, they will oppose the specific performance. So you do one thing, or any amount is due by you, sir.
No amount is due.
So whatever money has to be paid to the bank, the mortgagor becomes liable to pay, isn't it, sir?
Of course, sir. Of course.
Or else you ask the alternative relief for the return of the money.
Okay, sir.
Salina.
But the suppression the facts and make the purchase.
That's the reason that the indemnity clause is always there, isn't it, sir?
Then is there a liability?
No, but you may have a liability. Enforce it against the mortgagor. But as far as the bank is concerned, they are interested in their money. You have purchased it without notice also, but you will have to say you are a bona fide purchaser.
Of course, we are bona fide. We made all inquiries to purchase the same.
No, but one thing, that the equitable mortgage will not be entered in the EC, sir. EC will only show registered documents. If it's only by deposit of documents, then the question is, it will not be mentioned. But that is the reason, sir. Normally, in all these bank matters, they suppress the material. If you ask for the alternative relief also for return of the money.
Okay, I prayed that for prayer in my specific performance.
Yeah. Or else you pay the banker and get the documents ready.
Okay.
Right.
Okay, thank you, sir.
Right.
Salina, you have a lot of questions to ask, but I think you have a number of questions, Salina.
Sir.
Krishna,
can I ask a question, sir?
Just a second, sir. Just a second, sir. So there are a lot of questions as a single lady. That is Salina. Sir, Section 5 is the only case. Appeal and certain applications like bringing LRs on record. Does it require to apply to other applications and suits?
As far as suits are concerned, Section 5 doesn't apply. As far as appeals are concerned, it applies. As far as execution petition is concerned, within 12 years, you can file any number of execution petitions you like. But as far as suits are concerned, once it gets time bar, section 5 doesn't apply, please.
Sarina, I hope you need to interact with these many of questions so people can even come into the picture. They will also listen to your questions. I know you are traveling in a bus, but seriously, these are so many questions. People need of this kind of questions. That is better. We have an open board discussion tomorrow. Can we have that, Sarina? Salina, am I audible for you? All right, tomorrow we will have a discussion. I understand it's a crowded bus. Tomorrow we'll have a question here again on your questions. We'll have a copy of it and we'll have a discussion, thorough discussion tomorrow. Is that okay? All right, thank you. Mr. Ramana.
Sir.
Please go ahead with the questions.
ఇప్పుడు నోషనల్ వాల్యూ ఎట్లా కడతారు సార్? అది ఒక నోషనల్ వాల్యూ గురించి ఎక్కడ
రాశారు? నోషనల్ వాల్యూ ఎక్కడ రాసలేదు సార్, కానీ నోషనల్ వాల్యూ అనేది ఇప్పుడు కోర్ట్స్ 30,000 రూపీస్ అని ఫిక్స్ చేశారు.
నౌ ఇట్ ఇస్ అప్డేటెడ్ టు 50,000.
30,000 is the amount, notional value. But if you see the judgment of Justice K. Lakshman on same notional value only, he says, as far as injunction is concerned, court cannot fix arbitrary rate. It is so notional value means only a nominal figure. That's what you have to understand. But unfortunately, what is happening is courts are fleecing the parties as far as court fees are concerned.
Any more questions? Rajgaru, you are asking certain questions. Mr. Raju, Krishna Raj.
Yeah. Sir, in the previous case where the seller took the 30 lakhs and the mortgage was pending, what is the recourse of the buyer against the seller? Can he file? What is the criminal case can he file?
He can definitely enforce that indemnity, sir. Having filed a civil suit, he cannot resort to criminal case now. The question is, he has to ask for return of the money plus interest part of it if he wants to get back his money. But if he wants to assert saying that it's a bona fide purchaser for value without notice, the question is his defense will not stand. Because as far as equitable mortgage are concerned, they are not entered in the EC. Why? Because unless it's a registered document, the registered documents alone are entered in EC. But other things are not entered. The question is he should have given a paper publication before entering into that agreement. That's a mistake he has done.
So there is no recourse. He has to either lose 18 lakhs.
He only gets his money back. Or else he must resort to pay back the banker and get the documents released. And then proceed against the seller for the money which he has paid, because he gets subrogated. Why? Because against defective title, indemnity clause is there. He has not disclosed it.
Right, sir. Thank you.
All right, thank you. And I request everybody to stay online. Don't leave the class. We have a small discussion. I need your opinion and a poll also. So, any more questions you have, please go ahead.
So, regarding easement one, sorry.
Venkat Reddy garu, please go ahead.
Namaskaram, sir. Kindly explain on special court jurisdiction, my lord.
Please.
What is the question, sir?
Yeah, and the land grabbing act is another special court, and the civil jurisdiction is special court. Once land grabbing case is the jurisdiction వచ్చి special court entertain చేయాలి కదా సార్.
అయితే తెలంగాణ స్పెషల్ కోర్ట్స్ ఉండే ఇది కూడా ఉండే. It has been abolished. Now you have to go to the district court only, but district court I doubt whether they take LGOPs, or else you have to go to the high court only, sir.
Sir, LGOP is concerned on June 2018. The LGOP land grabbing act is abolished, sir.
So LGOP now doesn't lie to the district court, sir. They're not entertaining it also. Only you have to go by way of a writ. You have to file a writ in the high court.
Sir, okay.
Any more questions? Nataraj garu, you are asking certain questions.
Yes, sir. Regarding easement, when sir was saying that if we use one property for 20 years, and if the neighborhood was not constructed, after 20 years, if we construct, and such construction structure obstruct the lighting and whatever the things, then what is the status of the
remedy open to you is to enforce your easementary right by saying that not to obstruct your light, air, and ventilation. Or if he wants to, if he opens a window, to stop the window being open, which affects your right of privacy, Or suppose you got a right of ingress and egress, and that's the only way not to stop that particular way as far as you are concerned. Suppose it's a
So we can,
yes,
sir.
Please.
So we can object to that.
You can not object. You can also enforce your easement right.
Easements rights.
Okay, okay.
Your right over your neighbor's property.
Okay.
Any more questions?
Thank you, sir.
Any more questions? All right. There's a small announcement here. Please, I request to switch on your cameras if possible. If possible, I'm asking if you switch on your cameras. Good evening, everyone. That's nice to see everyone on a one boat.
Good evening, sir.
Good evening. It was very good. I mean, a huge response to the people who are giving us a Dharma Legal. And thanks for the support which was given, extended by each and everybody, our own people from our own community. Okay. Here is some announcement. We are coming up. So I require your feedback, what we have to do. Sir says that he is trying to put on his arguments on the bench, how it will be taken care, how it is going to taken care, and how in interim injunctions or any IAS to be argued, any kind of particular issues, any kind of other issues which are really addressed in the bench in a proper way. He want to address in online to train all our fellow advocates. So are you ready to have that kind of discussion? Is it okay for our people or not? If okay, we will have a design. We will design in particular about 1 or 2 days, and then we go ahead according to that. Because huge knowledgeable things which doesn't happen in everywhere. Any junior or any senior advocate, sometimes somewhere we will have some kind of discussion in the benches, especially in a senior bench or a junior bench or any kind of bench. You have any objections? Please raise it. Please raise your objections if you have any kind of objections.
No, sir.
Vasant Raghav, what do you say, sir?
Sir, it is very good for the sir. I welcome the article.
It will be definitely open port online. And sir, homework is some. అందరికి హోంవర్క్ ఇస్తాం అంటే ఒక నెక్స్ట్ డే కనుక మేము ఏదైనా ఇలాంటి పెడుతున్నాం అంటే వీ విల్ హ్యావ్ అన్ హోంవర్క్ ఫర్ యూ సేయింగ్ దట్ ద కేస్ ఫ్యాక్ట్స్ విల్ బి గివెన్ టు యూ మేబీ యూ నీడ్ టు డ్రాఫ్ట్ యూ నీడ్ టు సే టు అస్ అండ్ దెన్ యూ నీడ్ టు ఆర్గ్యూ ద కేస్ either side. This will be a practical experience.
Will be elated, sir. We will be very fluent in the case.
That is the reason I'm asking. Anybody have an objections? Please raise your objections. This is an open port. We don't have any kind of objections. Taking your feedbacks and making it sure to come into implementation also. Please.
No, sir.
Any objections from any corner? Please raise your voice.
Hope the subject matter we discuss here are not sub judice.
Absolutely. Because sir says that he has argued number of cases, typical cases which comes under an ICU. So he built up the case in taking that kind of matters, and he has won so many other cases. So he would like to extend this kind of arguments, this kind of making some files, IAS, how to open, how to reopen, these kind of things which come across. So he want to give an exposure to our fellow advocates who are very much interested. There is no compulsion if you are interested only. Any objections? Yeah, please. I don't want to continue. I don't want to waste your time or my time also. Sir, can I? Small discussion. Please raise your voice. Otherwise, no problem. No objections. No objection. Thank you. We are coming with next is Family Act, Contract Acts, Succession Acts. And in limitation, we have a huge number of files which are lying in my office. I will give you the case gist in coming days. You have to write that and you have to give an argument online. Nobody is small, nobody is big.
And we are not going to belittle anyone if you have committed any faults. We learn by mistakes. Please bear that in mind. The other day, I had a conversation with one of the district judges because most of you are appointed commissioners in courts. So please remember when you record the cross examination, be very, very attentive. Number one. Number two, record the proceedings properly. And another thing, record it correctly. And also, I'll give you the practical hints which you have to follow when you're recording the evidences through commission, please.
That is the reason. Okay, sir, Vakaraj garu, are you okay with that, ma'am? If you're okay, please raise your thumb. If everybody is okay with it, please raise your thumbs. That's enough.
One suggestion, sir.
Please go ahead, sir. Who is this? Vasant garu, cheppandi.
It's better to give some citations whenever it's necessary, sir.
Sir, citations will be given. See, we will definitely provide you the case laws, citations, which are required for the particular aspects. And a huge book is there with us for citations only.
Okay.
Which lies in my office every day. That's it. We will take it as our regular basis.
Sir, it will be, if it will be kept for our reference, it will be very benefit to us, sir.
Sir, reference me ఇవ్వడానికి అభ్యంతరం లేదు కానీ 800 పేజీలు సార్ అది. That's 800 pages. It's still going on.
We will come there, sir. We will come there and see.
Let's see, sir. We'll have a physical discussion also in coming days. We are keeping that discussion also in Hyderabad.
Okay, sir.
Any kind of questions you have, you can come through.
Yeah.
Cheppandi, madam.
Yeah. Shall we have a language this thing saying that let's go in English because that will be an encouragement to everybody.
I totally understand, madam. I totally understand. People who are staying in district courts, they have been coming from the Telugu language only. They will be reluctant. Some people are feel little bit uncomfortable when they speak in. So we will try to. We'll fine tune it, man. Definitely, will take away your call.
No. What I'm suggesting is this will be a practicing session for them too.
Yeah, absolutely, ma'am. That is the reason for this particular idea. Last 2 days, we have a brainstorming in the office itself, saying that what we have to do next. We don't want to be regular, like a stereotype. I can say that.
Yeah.
We just want to give an encouragement to our own fellow advocates.
Yeah, this would be a very good and ideal platform.
Ideas exchange is always there, sir. Ideas exchange is always there. Any kind of questions you have, please open up, ask me the question. We will also learn from you. Please understand that. Yes, sir, everybody is okay with it. Vasant garu, I need your answer, sir. Me gurinchi I'm waiting. Me question lekkunte maaku eppudu.
Yeah, eagerly waiting, sir.
Sir.
All right.
Sir, summons.
ఎవరు రమణ గారు చెప్పండి
టైం ఎక్కడ
చెప్పండి సార్.
సార్ సమన్స్ ఇప్పుడు సర్వే వాయిస్ సూట్ ఫైల్ చేశాక నెంబర్ అయ్యాక డిఫెండెంట్ కి సమన్స్ వెయిటింగ్ లో ఉంటే అక్కడ కరెస్పాండింగ్ అవ్వకపోవడం వలన ఎంత టైం ఇస్తారు అలాగా?
సార్ సమన్స్ అవ్వడానికి ఒక్కొక్క డిస్ట్రిక్ట్ ఒక్కొక్క కోర్టు ఒక్కోలా ఫాలో అవుతుంది సార్. ఎవ్రీబడి ఇస్ ఫాలోయింగ్ వన్ కైండ్ ఆఫ్ థింగ్స్. దట్ ఈస్ మినిమం ఆఫ్ 3 weeks టైం ఇస్ గివెన్. సార్ 3 వారాలు టైం ఇస్తున్నారు సార్. బేసిక్ గా 3 weeks ఆఫ్ టైం ఇస్ గివెన్. లేదు సార్, మీరు ఒకసారి ప్రెస్ చేయండి. ఫస్ట్ సమన్స్ వచ్చేసి మీకు టైం పడుతుంది. సెకండ్ సమన్స్ నుంచి మీరు కొంచెం ప్రెస్ చేయండి. Are asking in the session.
Sir,
definitely it will come to
a give you a practical approach, sir. You accompany the process server along with him. This is what is done, sir. It's a practical.
Sir, ivi practical అని మనకు తెలుసు. కొన్ని విషయాలు మనం పర్సనల్ గా మాట్లాడుకుంటేనే బెటర్. Please give us a call. We are here to help you out.
అంటే అది ఎక్కడైనా అంటే జడ్జి
గారు రమణ గారు మీకు ఎందుకు చెప్తున్నానంటే వీఆర్ ఆన్ లైవ్. వాట్ ఎవర్ యూ స్పీక్ ఇట్ విల్ బి టెలికాస్టెడ్. ప్లీజ్ మైండ్ దట్. మీకు ఏది అవసరమైనా ఒక ఫోన్ చేయండి. ఈ విల్ గైడ్ యూ. మాకు తెలుసా ప్రొసీజర్ ప్రాసెస్ మేము గట్టిగా పట్టుకున్నాము. మీకు ఏం కావాలంటే చెప్పండి. వీ హియర్ టు హెల్ప్ యూ అవుట్. సార్ ఇంకా ఎవరున్నారు? శామ్, యూఆర్ రైజింగ్ యర్ హ్యాండ్. ఎనీ క్వశ్చన్స్ ఫర్ యూ?
No, sir. I was
All
just telling you that there is no objection. That's
All right. Thank you. And Ravi Kiran Garu, any questions for you?
No questions, sir.
All right, thank you. Yelleshwar Kumar. Are you ready?
Sir, I have less knowledge on civil only, but
No problem, we'll learn it, my dear. This is an open board. That is what we are there with you. ఓ పెద్ద ఆయన మరిచెట్టు ఉన్నాడు, ఆయన దగ్గర ఎంతకాలం నాలెడ్జ్ తీసుకుందాం.
Yes, sir. Thank you, sir. I am trying to get complete knowledge.
Thank you, and thanks for everyone. We'll see you tomorrow again. Homework చేసుకోవడం మాత్రం రెడీ అవ్వండి.
Thank you, sir.
Homework ఇస్తా అందరికీను.
Thank you.
Thank you, sir.
Alright.
Thank you.
Come back to the school again. Bye.
Thank you, sir.
Bye.
Yes, sir.
Bye, sir.